All right, guys. So I've had the opportunity to review the contract, and there are a few sections that I wanted to review with you, just so we're all on the same page with how to proceed here. So there's three things that I want to do with these sections that I will review with you. One is identify the business, financial, and legal risk in my analysis and the probable consequences should any of those arise. Okay. Number two, what language I would recommend we either modify or void to minimize our risk or our overall exposure from a legal perspective. Number three, what actions that I recommend we take based on my assessment. Okay. So there's three particular sections that I wanted to review with you, my modifications and my reasoning for recommending those modifications. Let me pull up my screen here. And so let me pull up that contract. All right. So you should be able to see my screen. The first section that I want to review with you is Article 3 closing. Okay. So I've made some modifications to the articles, and I have transcribed my thoughts and reasonings on the side that I will review with you. The first is the location and timing of the closing. I want to make sure that we're all in agreement with recommending the time, place that the closing will take place. And what this will do is make sure that both parties understand that there is a time deadline to do all of their due diligence and have all of the documents and the necessary items to procure this deal in time for this closing. So identifying the location as well as the time kind of sets that pace. Okay. Scroll down. So the items that I've either modified or added are in yellow. And if you see section 302A, at the closing, seller shall deliver to buyer all documents required for the transfer of assets and liabilities that will include but not limited to the following. So I wanted to add this because typically in contracts, although it covers a lot, it may not, everything that pertains to us and what is at risk to us may not be listed in the agreement. So I wanted to add that clause. It may not be limited to, as there may be more items that would be necessary or that would be of satisfactory for our due diligence. Okay. If we continue down to item 3, right here. Okay. So I wanted to replace, it was special, a special warranty deed here, and I want to replace that with a general warranty deed. That just provides a more robust level of protection to what a general warranty deed provides versus a special warranty deed. So that gives us a bit more jurisdictional control that's in the favor of us, the buyer. Okay, let's scroll down to section 4 here. So intellectual property and everything that goes along with that is separate, simply because that's pretty much the only part of the contract that we're going to have to resubmit to third party and regulatory agencies, being whether that's a U.S. Patent Office, a Trademark Office, a U.S. Copyright Office. And there's a lot of things that comes with intellectual property that may be need to articulate in a separate manner than the contract itself. So simply it would be redundant to have to send the entire M&A agreement over to any of these regulatory agencies just for the intellectual property. So I recommend we get this particular asset assigned in a separate short form or a single intellectual property assignment agreement. Okay, let's scroll down. So let's go to Article 4, representations and warranties of the seller. If we look at the bottom of section 401 right here, what I wanted to do was remove all the language that had material adverse effect. And I wanted to replace it with a more broader scope, that anything that could be reasonably expected or any materiality qualifiers. And one of these were just making sure that the licenses are qualified, that they're all in good standing in the amount of losses and the inaccuracies or representations of the sellers for those assets, okay? Section 402, this particular sentence that I highlighted in red, I recommend we delete it altogether, but I want to leave it in here just to show you what I'm thinking about here. So it says similar laws affecting creditors' rights generally and by general principles of equity. So this particular clause removes the element or removes our ability to bring a breach of representation claim against the seller, and we want that as a buyer. So we want to be able to put the onus on the seller to procure all the documents that we need in a timely and informed way, and not putting us in a subsequent or secondary position to any creditors that may have those rights as well, okay? Section 404, create any party the right to accelerate, terminate, or modify contracts, including licenses and permits. So this particular representation is what I recommend we add, okay? So we want to expand a list of any adverse consequences in these subsections to cover a much more broader scope. And so this particular clause does that for us, okay? I added one more subsection in D here, and it reads, asset purchase agreement and acquisition will not result in any encumbrance on any of the purchased assets. And once again, anything that particularly had material adverse effect, I wanted to replace with either materiality qualifiers or anything that could be construed or reasonably expected to be materially adverse. And again, this is much more comprehensive, and this prevents any violations or breaches of materials, okay, on our end, and puts that back on the seller, all right? All right, if we scroll down here, I wanted to add that there are no undisclosed liabilities. And although liabilities and assets represent a lot, again, there may be some liabilities that may be withheld for reasons that may not be important to the seller, that may be important to us. So we want to make sure that all liabilities as well as assets are disclosed, whether they're paid, not paid, or any items out there. We want to know about that, okay? And we also want to put it on the seller that any financial statements delivered to the buyer are complete and correct. And I wanted to add one note here from an accounting process. I think as the acquirer of this business and their assets, we should have some share, if not complete internal accounting control. And I recommend we at least have some type of share in that, okay? Again, a lot of these areas I have recommended that we either add or modify material adverse effects with anything that could be reasonably expected, okay? Again, same thing there. Section 409, all tangible personal property and the purchase assets are in good condition and not in need of repairs. This is a representation that I recommend we add. This provides us some assurance that the assets are in good condition, and it would remove any assumptions on our end and place the burden to procure upon the seller, okay? So I think this is very important. That could cause some type of issues should we not put this clause in there. Under section 4.11, intellectual property, okay? Again, I wanted to replace any material adverse effects with a more broader scope. And material patent rights, property, software, and data security are three subsections that I wanted to add there. And I wanted to make sure that all of these were part of the disclosures and part of our rights to know the location and to provide all of this to us to review at our due diligence, okay? Again, I wanted to replace any material adverse effect with a more broader scope. That's what you see there. So I did that in every section that represented a material adverse effect, and I wanted to replace that with anything that could be reasonably expected, okay? All right. Under employment matters, section 4.16 employment matters, particularly section D, okay? Seller to provide a list of all current employees' compensations and employee agreements to the buyer. I wanted to add this. And so what this does is that it discloses all the employee information just to expand the scope and ensure compliance with the WARN Act. And so the WARN Act stands for Workers Adjustment and Retraining Notification Act of 1988. And this act requires that any employer with 100 or more employees to provide a 60-day advance notice of any closings or layoffs. And so obviously there are going to be a group of employees with the target company that we would want to retain, and there's others that we may end up laying off. We want to make sure that we're giving them that proper 60-day notice for that, okay? And so that is the reason for adding this subsection there. And let's go down to Article 7, conditions to closing, okay? So I'm going to scroll down, particularly to section D and E. These are ones that I have added. Seller shall obtain all third-party consents listed in the section 4.03 of the disclosure schedules. And E, buyer shall have the right to waive a required consent that the seller may not be able to obtain before closing. So I wanted to remove any element of last-minute consents or signatures that may be needed for any of the party sellers that are maybe out of touch. They cannot reach them, but that particular consent could delay or interfere with the actual closing itself. And I wanted us to have that right to either waive or to require that consent, okay? So I think that's important for us to have that. If we go to section J and K, these are two additions I recommend we add. One, buyer obligation to close is subject to obtaining financing to pay the purchase price. Very important here, because as it states right now, it appears that we have the sufficient cash to purchase the company and assets with cash only. That is not the case. I wanted to make it clear the importance of obtaining that financing. And this also goes into section K, which puts any of these obligations that are subject to the satisfactory completion of our due diligence with investigating the target business. And this could be for qualification purposes of the financing. But the financing is a very important component of this acquisition. And I want to make that a subject or a condition that is conditioned prior to closing, okay? And this also provides us the ability to walk away should any of these or should the financing itself fail, okay? All right. So that is the three sections, particularly that I wanted to cover with you. I hope this is very helpful. Obviously, we can get on a call and review it in a much more thorough pace and kind of discuss some other areas that we may want to consider modifying or trying to remove or minimizing our risk. But I hope this helped, and I'll talk to you guys soon, okay? See you soon. Bye-bye.